Hello and welcome to TaxPundit. The case under discussion is Kamal Kumar Khetawat versus the Union of India, Jharkhand High Court, pronounced on 23 June 2026. The case involves Kamal Kumar Khetawat, who was subjected to a search and seizure operation under Section 132 of the Income Tax Act. During the search, cash amounting to Rs 9 lakh was seized. According to Section 132(b)(4, the revenue must complete assessment within 120 days from the last search. However, no assessment was initiated within this period. The petitioner demanded a refund of the seized amount with interest. The cash was eventually refunded on 5 June 2026, but no interest was paid, leading to a writ petition before the Jharkhand High Court. The key issues before the High Court were, first, whether the revenue is liable to pay interest on the seized cash when it is refunded after the statutory 120-day period without completion of assessment. Second, if interest is payable, what should be the rate and the period for which it runs. And third, whether the court, exercising its extraordinary jurisdiction under Article 226, can award interest at a rate higher than that prescribed under the Act. The petitioner argued that interest at the rate of 18% per annum should be awarded, relying on Supreme Court and Allahabad High Court precedents. He contended that the revenue's inaction in completing the assessment within the prescribed 120 days caused financial loss. Since the refund was delayed, compensatory interest should be granted under Article 226 to remedy the injustice. The petitioner limited his claim to interest only, as the principal amount had already been refunded. The revenue opposed the claim for interest. They argued that as per Section 132(b)(4)(a), the statutory rate is only 0.5% per month, that is, 6% per annum. More importantly, they contended that interest under Clause B runs from the expiry of 120 days to the date of completion of assessment. Since no assessment was completed, the period for interest had not even started. Therefore, no interest was payable. They also resisted any higher rate under Article 226. The court examined the language of Section 132(b)(4). Subsection 4(a) provides for simple interest at 0.5% per month on the excess amount refundable. Subsection 4(b) specifies that interest shall run from the date immediately following the expiry of 120 days from the last search to the date of completion of assessment or reassessment. The revenue argued that if no assessment is completed, the end date never arrives, so interest cannot accrue. The court rejected this absurd interpretation, holding that the provision is compensatory and must be read to avoid unjust enrichment. The court clarified that in cases where no assessment is completed, interest cannot be open-ended. Instead, interest must run from the expiry of the 120-day period until the date the seized amount is actually refunded. This interpretation prevents the revenue from benefiting from its own delay. Applying this, the interest period started from 29 August 2019, which was the day after 120 days from the last search on 1 May 2019, and ended on 5 June 2026, when the cash was finally refunded. The petitioner argued for a higher rate of 18% based on precedents. The court recognized that under Article 226, it has the power to grant compensatory interest when the revenue's inaction causes loss. However, in this case, the court found that the statutory rate of 6% per annum adequately compensated the assessee for the delay, given the specific facts. The court noted that the extraordinary remedy under Article 226 can step in, but it is not bound to award a higher rate if the statutory provision already provides a fair mechanism. The revenue tried to justify the delay by stating that a reference had been made to the Director General of Income Tax, Vigilance, to fix responsibility for not completing assessment. The court categorically rejected this as a reason to withhold interest. The internal inquiry is meant for departmental accountability, not to deny the assessee their due. The court ordered that if the interest is not paid within 6 weeks, the rate would double to 12% per annum and the additional amount would be recovered from the officials responsible after giving them a hearing. The High Court directed the revenue to pay simple interest at 6% per annum on the seized amount of Rs 9 lakh. The interest period is from 29th August 2019, the day after the expiry of 120 days from the last search, up to 5th June 2026, the date of refund. The payment must be made within 6 weeks from the date of the order. If the revenue fails to comply within this period, the interest rate will increase to 12% per annum and the additional interest burden will be recovered from the officials who caused the delay, after giving them an opportunity to be heard. The Jharkhand High Court reinforced the principle that the revenue cannot avoid paying interest by simply failing to conduct assessment or by citing internal inquiries. The interpretation of Section 132b(4) must safeguard the assessee's right to use their own money. Even if the statutory rate is only 6%, the Constitutional Court can step in to ensure justice. This judgment provides a clear remedy for taxpayers who experience delays in refund of seized cash, strengthening their position against bureaucratic inaction. One common question is about the interest rate. According to Section 132b(4)(a), the interest rate is 0.5% per month, which works out to 6% per annum. This is the statutory rate, though courts may award a different rate under Article 226 in exceptional cases. Another frequent question is about the start date for interest. The law says interest begins the day after 120 days from the last search. For example, if the last search was on 1st May 2019, then 120 days later is 29th August 2019, and interest accrues from that date. If the revenue does not complete assessment within 120 days, the interest period does not end. The court ruled that in such cases, interest keeps running until the actual refund is made. This prevents the revenue from indefinitely delaying assessment to avoid paying interest. To ensure compliance, the court imposed a penalty. If the interest is not paid within 6 weeks, the rate doubles to 12% per annum. Moreover, the extra interest will be recovered from the officials responsible for the delay after giving them a fair hearing. This serves as a strong deterrent against further delays. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website taxpundit.org. Feel free to write to us or message us on WhatsApp at 932-630-6668 for any assistance. Don't forget to subscribe for more landmark updates.